not find this officer's conduct reasonable. So I don't believe there's jurisdiction at this stage, and I don't think there's jurisdiction to assess the search of the wallet claim because I think that issue was waived.
I'm having trouble understanding your jurisdictional argument. I mean, they're entitled to accept plaintiff's facts. I realize they don't do that, but they're entitled to accept plaintiff's facts as they still say there is no disqualified immunity. And we have jurisdiction to hear that. I don't understand how you can argue there's no jurisdiction.
Well, I think that's a good point, Your Honor, and I think there's...
It's really more of a question.
It's a question? Okay.
Yeah, I mean, how can there not be jurisdiction? I mean, we can say they're wrong, and I think they are wrong myself, but the fact that they are wrong doesn't deprive us of jurisdiction.
Well, I think in ACT UP v. Portland and in Johnson v. Bay Area Rapid Transit, 2 Ninth Circuit cases, and also in Johnson v. Jones, which is a U.S. Supreme Court from 1995, there is an indication that an interlocutory appeal on a denial of qualified immunity that was based on disputed facts in the categories of what the officer believed or perceived, and in the category of what actually transpired between the officer and suspect, that those types of fact determinations were so highly fact-specific and subject to credibility determinations and inferences that they were more appropriately decided by a jury.
So your opposing counsel has made such arguments, and that muddles this up, but to the extent he's also arguing that assuming plaintiff's facts there would be qualified immunity, which I think probably charitably read his briefs also argue, we have jurisdiction over that type of argument, don't we?
Sure. I mean, I think
it's probably a loser, but doesn't matter of jurisdiction.
Okay.
You're willing to take a victory any way you can, right?
I think that the jurisdiction issue for us is more something that we thought contributed to our sentiment that this appeal was ill-advised. It was just one more reason it was ill-advised, because there are indications that jurisdiction is premature.
I think Mr. Filippi is coming around to that view.
Okay. And then the second reason we think the appeal is frivolous is that the law setting forth legal parameters for a Terry stop has been very well developed, well settled, and clearly established by this circuit in addition to other circuits.
So can I ask you a question about that? So I really only have one question for you that I'd like you to help me with, which is this Gallegos case. I think you can distinguish your case from Gallegos such that maybe we could say there is a constitutional violation here when there wasn't in Gallegos, but I'm having trouble understanding why Gallegos doesn't create enough uncertainty in the law to have there be qualified immunity on the investigatory stop part of your case. You have a lot of other claims, but on the one part about whether the police could detain him for long enough to figure out if he was the right person or was a criminal, it seems like Gallegos was very broad in saying what police could do to investigate something and detain someone in the meantime. And I wonder if it creates enough uncertainty in the law that there would be qualified immunity on that claim.
And I don't think it does, Your Honors, because Gallegos is one of dozens of cases that talk about when an officer may exceed the traditional parameters of a Terry stop.
So can you point to a case that has facts that are more similar to this one than Gallegos? Because Gallegos is somewhat similar.
Actually, it's not similar. In Gallegos...
Okay, can you point to another case than Gallegos that will help me see why you think they can't stop him like this?
Why they can't stop him? Johnson v. Campbell would be the best. It's out of the Third Circuit.
Okay, how about this court?
This court would be U.S. versus Delviso. U.S. versus Ricardo D. Washington v. Lambert. U.S. v. Miles. United States.
Can you tell me why you think they're more similar to the facts here than Gallegos?
Yes, because in cases, all of the cases where intrusive means have not been allowed are more like this case. In other words, Delviso. Delviso involves a case where a car is pulled over and the suspects are ordered out at gunpoint. Delvizo's ordered out at gunpoint, told to get on the ground, and cuffed.
And had there been a tip, like a 911 call in Delviso?
Delviso, the suspect had been under surveillance for drug trafficking. And in Delviso, the court found that those tactics constituted an arrest because they exceeded the bounds of Terry.
So in Delviso, there was more than a tip. There was actual evidence of an actual specific crime.
They had been surveilling Mr. Delviso because they thought he was part of a drug trafficking program. And when they pulled him over, they ordered him out of the car at gunpoint, I think told him to get on his knees or the ground, and cuffed him. The court found that was a de facto arrest. That was not a Terry stop because there was no indication that Mr. Delviso was armed, had just there hadn't just been a violent crime. There wasn't information suggesting that he was about to commit a violent crime. There was no information that he was carrying a weapon. And because we did not have...
I'm looking at Delviso, so I apologize for not remembering exactly, but it seems like the Delviso issue was, it says, there was no evidence suggesting that Delviso was particularly dangerous, especially once he had stepped out of the van, had been frisked, and was lying on the ground. So I'm not sure the court thought it was improper to stop him. The issue was just that after that, they drew their weapons.
They did not think it was improper to stop him.
So how does this help you with the seizure of your client here for some time while they investigate? I mean, no weapons were drawn.
There is no authority that I have found in this case, this circuit's precedent or any other circuit's precedent, that allows a citizen to be stopped and held just because an officer needs to investigate something.
Except that's kind of, I mean, isn't that what happened in Gallegos?
Well, no, Gallegos was a situation where the officers made a violent crime had occurred, first off. And minutes later, the officers in a chopper see a man walk out of the victim's home, or near the victim's home, get in a car and flee. The man matches the description of the man who tried to break into the house. So the officers have reasonable suspicion to stop the person. There's been a report by a victim of an actual crime, a violent crime. Somebody's trying to break into my house. I have a restraining order against them. I fear for my life and limb. After that report, the officers who are overhead see a man matching the description flee in, I think, a pickup truck or a vehicle of some kind.
He's not fleeing, right? It turns out he's not even the person.
Not
so
fleeing.
He's driving away.
Right. But a crime has clearly been reported, and it's a crime that threatens life and limb. So the officers have reasonable suspicion that criminal activity is afoot. They think this man is part of it. So they stop him. And they stop him by ordering him out of the truck at gunpoint. He complained not that this wasn't a proper Terry stop. He complained that those were excessive measures because I'm not armed, I'm not even the right guy. I think what the court was saying is, well, there had just been a violent crime. You were believed to be the right guy. You were believed to be fleeing, and these beliefs were all reasonable under the circumstances.
So I think you're making a good argument about why we could say there's a constitutional violation in this case, but not, even though there wasn't in Gallegos. But isn't it close enough that a police officer could think Gallegos meant that they could stop someone while they investigate, especially if they don't draw their guns? I mean, it's at least, it seems at least arguable to me, which I think is what qualified immunity is about.
I don't think so, Your Honor, because I think Gallegos is taken out of context. There are too many cases authored by this court that lay out the parameters of a proper Terry stop.
Isn't one of the distinguishing factors of Gallegos is that this man is outside his own house?
Sure, yes.
So this is not somebody that's on a highway, on a street, or traveling in a car. And at that point, what do you do? Then they can get behind the wheel and drive off.
Did they know, though, at this point that it was his house? I mean, they were following a tip that someone...
He came out of the house, right?
He was seen crossing the street and entering a vehicle right outside of the subject house.
But in your client's case?
In my client's case, there's not even a report of crime. In my client's case, you have a third party.
But he is seen coming out of the house.
My client?
Yes.
Yes, Your Honor. He is seen coming out of his house after having...
But this is not a highway situation where he's in a highway and he's got a vehicle. Is there a vehicle involved?
There's a vehicle involved in Gallegos.
No, in this case.
No. There is no...
So it's not like he's about to drive off. He's about to...
There is not a single scintilla of evidence that my client is attempting to flee or leave. Not a scintilla. There's not a scintilla.
He's on the ground partly, sort of recovering from being...
He was attacked because he did not place the contents of his right hand, which was his military ID and his wallet, into the palm. This was done. He didn't do this. And he got attacked. And my point is that Gallegos bears no similarity.
Right, but we're talking about the detention after the attack. We've got the attack, and that's one issue. And then he gets placed in the police car, right? He tries to handcuff. Are there any further facts that justify that?
No, because all intrusive means, any intrusive mean on a Terry stop, has to be justified.
I mean, he's not getting up and running away.
Right. So all intrusive means on a Terry stop have to be justified by the Washington versus Lambert factors or by other factors that maybe haven't been developed yet that contribute to a reasonable belief that the officer or some other party safety is threatened or that the person is...
Okay, you guys get the picture. If you want to see more of this video, here you go. You can go look it up on YouTube. Make sure you subscribe. These come out every week, 2 or 3 times a week. So when they put up new videos, you'll be notified. United States Courts of Appeal, and this one happens to be the 9th Circuit. So this is what the lawyers do not want you to know. So I suggest you go subscribe and stay up on the information. Stay up on the information. So you can go to Google. You can look this up. You can go to YouTube. Check it out. And make sure you give me a thumbs up and make sure you subscribe. So when I find new stuff, I will bring it to you.